Welcome back to Scuttlebutt Lodge and another stump speech from God's country. Last week, I was in the Superior Court of Justice here in Ontario to have my many charges against the Reopening Ontario Act, my many charges against the mandates during COVID heard on a matter of the Constitution in front of Justice John Callahan. The Crown conceded they indeed violated not just my Charter protected rights and freedoms, but each and every Canadian's, each and every Ontarian was and had their protected freedoms and rights violated. But Ontario's Crown said it was all reasonable. It was all justified. And if they're correct, we no longer live in a democracy with elected representation. We no longer have a constitution that constrains the government nor protects our freedoms. And there's 4 key points that the Crown raised in their prosecution against me. The first one that the Crown asserted was that as long as the government has a belief that this violation is reasonable, as long as the Crown believes it is beneficial, and as long as the government has one paid employee who supports that assertion, then the Crown believes it meets the Oakes test. That's the first one. That the government does not have to have any evidence, they do not have to have any proof, and they do not have to rely on independent individuals to support that assertion. One of their own employees is good enough. And that's what the government did. They relied solely on people that they were paying for the support and recommendation to squash and prohibit anybody's exercise of freedom of speech, freedom of peaceful assembly, freedom of expression, or freedom of mobility. That's the first point. The second point is that although the government spent years collecting data and information about the spread of this counterfeit pandemic, they said it was impractical to use that factual data. All that contact tracing, every time you have to go to a restaurant or a movie theater and put your name down, your phone number, where you're from, all that information was impractical to use. It was the only information that the government relied on was the models and the projections developed by the very same people who were providing them the advice, the Ontario Science Table. And these guys were filling their pockets with they were filling their pockets with money, and they were filling themselves with euphoria over their newfound status in our province and how important they had become. That's number 2. The third point, that the government never considered the harms, the injuries, the consequences of these violations of our Charter-protected rights and freedoms. That was clear in the evidence before the court. The Crown is saying they don't need it. They don't need to weigh the costs against the benefits, the harms and injuries against the value. The government never bothered to even consider how these mandates would hurt So many people. People deprived of health care. Children deprived of schooling and education. People deprived of physical activity. The mental health, the suicide rates, the overdoses. None of that was considered. Nor the economic consequences, the bankruptcies, the foreclosures. None of it did the government once believe it was necessary to understand the harm it was going to cause. But really, the piece de resistance, if you like, the element that the Crown asserted, this fourth point, was that they asked Justice Callahan, they said to Justice Callahan that you cannot measure the merits of an individual violation of our Charter of Rights and Freedoms if it is part of a bundle of other violations of our constitutional freedoms. You heard me right. As long as the unlawful activity is bundled up with other unlawful activities, the Crown asserts they all become lawful and can't be individually adjudicated. They can't be individually measured. What that leaves us with, if the Crown is correct, if the Justice accepts these arguments, it is not just a de facto dictatorship, authoritarian regime that we live in. I shouldn't say dictatorship. It's an authoritarian regime. We may have different puppeteers in the top spots, in the premier spots, but it becomes an authoritarian regime when the government just has to state that they believe they should violate our rights and they have an employee that agrees with them. That they don't need to weigh the consequences of their actions. They don't need to rely on factual evidence even when it's available. And then, as long as we screw you many ways at the same time, then they all become legal. Thanks for joining me at Scuttlebutt Lodge. Come out to nomorelockdowns.ca. Visit me at nomorelockdowns.ca. You can donate to my other legal challenges, my criminal charges that are still underway in Ottawa. And make sure you hit the like button, share this with your friends and family members, and hit the notification button to get more updates from Scuttlebutt Lodge.